you for your patience. I will call to order the semi-monthly meeting, the State of Rhode Island Coastal Resources Management Council meeting to order. Today is Tuesday, June 13, 2023. I would ask that the record reflect the council members that are in attendance, as well as staff members as well. First matter on our agenda will be approval of the minutes of the previous meeting, that meeting being held May 27, 2023. I would entertain a motion to approve the minutes.
I have one correction to make.
Yes, Mr. Gagnon.
So on page 4, the line above the roll call, it should read, Mr. Willis confirmed for Mr. Gagnon that Save the Bay and the Infrastructure Bank made the only public comments and reviewed the proposed red line regulations. So I can just give it to Lisa.
Okay.
Thank you.
All right, with that change, I'd entertain a motion to approve them.
So moved.
Motion made by Ms. Reynolds. Is there a second?
Second.
Seconded by Ms. Hall. So any discussion? If none, I'll poll the council. Ms. Hall?
Yeah, yes.
Mr. Gagnon?
Yes.
Ms. Reynolds?
Yes.
Mr. Izzy? Aye. Mr. Gomez?
Yes.
I too, Raymond Coy, vote aye. The minutes are accepted. Subcommittee reports. Mr. Willis?
There are no subcommittee reports tonight, Mr. Chair.
Staff reports.
I have one item for staff report, Mr. Chair. 2 Fridays ago, I had the pleasure of attending a tour of the Block Island Wind Farm for the purposes of showcasing Rhode Island's energy infrastructure to the nation. On the trip was U.S. Energy Secretary Granholm, along with our 2 senators, Reid and Whitehouse, Congressman Magaziner. Also, Governor McKee and Lieutenant Governor Matos was there, along with a number of senators and reps here from the state. And it was very well attended, very well organized to showcase all the different types of energy initiatives that are going on in the state. And CRMC was very well represented, obviously, with our presentation on the wind farm. So that's it, Mr. Chair.
Thank you. We have 2 matters down this evening. First matter, application requirement of special exception before the full council for review and action on final decision. That would be 2022-02-065, Town of Narragansett. It's an application to construct a roof over an existing deck located at the North Beach Clubhouse, which is currently serviced by a removable tent. The project requires the issuance of a special exception to RICR-Redbook-650-20-00-01 Sections 1.2.2 parentheses B parentheses 1 parentheses C parentheses 3 parentheses AA-BB close parentheses, as well as Section 1.1.9 and Section 1.2.2 parentheses G for new construction located within the dune setback on a moderately developed barrier beach. It's located at Plat B, Lot 6, 79 Boston Neck Road, Narragansett, Rhode Island. Our representatives for the applicant or the applicant themselves present this evening. All right, why don't you come,
On Narragansett Parks and Recreation.
come forward and have a seat there.
So Kershaw, KERSHAW.
Is there anyone else that will be present or part of your presentation this evening?
Frank Carpowitz, my engineer. I'm sorry, Joanne McCrory, my engineer, and Frank Carpowitz, my architect.
Right. Before we start the presentation, anyone else present this evening on this application to speak in favor of the application? Anyone present this evening that is going to speak in opposition of this application? Okay. Amy, please, you're going to report on behalf of staff on this one.
Yes, thank you, Mr. Chair. As you stated, this application is before the council for the Town of Narragansett North Beach Pavilion. They are requesting an assent to change the removable tent structure over their existing deck to a permanent wood and beam 36-foot by 36-foot wood frame roof structure. This will essentially square off the structure footprint. The application is before the council for 2 special exceptions and 2 variances. The variances, section 1.1.9 and 1.2.2 are for the 50-foot minimum setback. The 2 special exceptions are 1.2.2 B1 C, G, double A, and double B. Those refer to a prohibition for expansion of recreational structures in a V zone, and all activity must be confined to the existing footprint. Staff has no issue with the 2 variances for the 50-foot setback. The work does fall within the setback of the dune and the beach coastal features. As far as special exceptions, the town of Narragansett did issue the building official sign-off for the work in the V zone. And the area could be considered substantially altered, which is one of the exceptions within the prohibition. However, the roof structure does result in an increase in structural lot coverage, which is still a special exception and not called out within the section. There will be no disturbance to the coastal feature, and all work will remain within a previously disturbed and developed area. It will be available to the public as well as for private functions, as the tent structure is right now. Reiterate, review staff has no problem with the variance request and defers to the council for the special exceptions.
Any questions of the council members of Amy? Okay. Mark, we'll just swear in the 2 witnesses that are,
Will
whoever will be testifying.
all 3 of you be testifying tonight?
I believe so.
Would you all please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Would you each please state and spell your names for the record?
Michelle Kershaw, Kershaw.
Joseph Amatori, Amatore.
Frank Karpowitz, Karpowic. Thank you.
Speak over you. I'm about to go with the mic.
All right, please proceed.
Thank you, sir. So I don't know if anybody's had the opportunity to attend an event at the North Beach Clubhouse. The structure sits between our cabanas and also our North Pavilion. Currently, it's been the practice of our department to do a bid for a tent company to put up a tent on the deck of the venue to help with inclement weather. No bride wants to be soaked on her wedding day, his or her wedding day. So the tents have become a constant fixture at this particular venue. Unfortunately, 2 years ago, we had a tent collapse, causing structural damage to one of our brand new doors and also the decking. Previous to that, we had a significant storm. The tent company, that was our bid company, decided to just drop the tent. That caused significant damage to our engineered plank flooring, causing us to have to file a claim against the tent company. And the replacement cost for the deck was $100,000. Due to the safety of and issues that we have with the tent, having the company not taking the tent down in a timely manner, leaving the tent up because the company doesn't want to take it down if there's just a couple of days before events. I'm respectfully requesting that we do get approval for this change, being able to build a permanent structure, therefore not having to worry about entering into a tent rental business for the people that rent the North Beach Clubhouse.
Would you say there's a compelling need for it?
The North Beach Clubhouse is our premier venue in the town of Narragansett. It is a very good revenue generating business that we have with the town. It's a very, very popular site for weddings, bar mitzvahs, parties, retirement parties, graduation parties, a whole host of activities. I think out of an abundance of caution, I think it is necessary, in my opinion, as the director, to move forward with a permanent structure. I find the tents are becoming a matter of safety for many different reasons. And I think a more permanent structure would alleviate the issues that we're having now with the tents. And also it would enhance the structure that is currently there, beautifying the area, I think, a lot better, and allowing for, I think, a better experience of having your event at the North Beach Clubhouse, being that it's directly on Narragansett Town Beach.
Any questions of Ms. Kershaw from council members? Yes, Ms. Hall.
Just to follow up on your question regarding the compelling public purpose. How does it provide a compelling public purpose that provides benefits to the public as a whole, as opposed to individual or private interests? You've just talked about renters.
Anybody, town residents, anybody can rent the North Beach Clubhouse. We have no restrictions on who can rent that venue for whatever occasion that they want. Compelling is a strong word, but I would say that most people wish to rent a tent for their event or function that they're having because of the threat of inclement weather, whether it's high wind, rain, etc. Again, this venue is an opportunity for anybody to enjoy, not just the people in town, but from people all over. And oftentimes people who do rent this venue, they often have cornhole in the sand and other small events, to help with their function. So they kind of incorporate not only the building, but really the deck itself is really what draws people, and being right there on the beach, having a full sand frontage is what really draws people to that vacation. Not so much the building itself, but the deck.
Thank you.
Thank you.
Mr. Chair,
Yes.
I do have one question, not of the applicant, but of Amy.
Sure.
Amy, could you explain a little bit about this structural lot coverage? Because this is an area that's already covered by deck. So by adding a permanent cover, you're upping that even though it's already over a built section of deck?
Yes. It is already it is already developed. It is an existing area of deck, I believe, with concrete underneath it. However, as far as CRMC Red Book regulations are concerned, roofed structures are considered structural lot coverage versus simply lot coverage, which is what towns consider. They'll typically include a deck or a patio or a driveway in lot coverage. We look specifically at structural lot coverage, so things with a roof. Tents are temporary, they don't count. This would be a permanent increase in structural lot coverage. And because of its location near the dune and within the dune setback, that is a prohibition under the Red Book.
Okay, so it wasn't counting at all without a permanent roof?
Not as structural lot coverage. It was counted as a structure. It was permitted, but it was not counted as structural lot coverage.
Okay, thank you.
Just to clarify, the building and the deck are built on piles about 5 or 6 feet above the sand. And right now, that portion of the deck is open to the weather. When we put a roof over it, and when there's a tent over it, it's still open on 2 sides. So although, I totally agree with Amy about the structural lot coverage interpretation, it's not like we're enclosing this area. All fall through the deck into the sand. So we're really just putting a roof over an existing deck, which is 6 feet above the sand, as opposed to enclosing that area.
Thank you.
All right.
And just to clarify the compelling, and there's no restrictions to anybody who can rent this deck or this facility.
What I'd like to add is, please, it's just some of the events that we have there annually. We have the Narragansett Lions Club annual Thanksgiving and Christmas dinner, which is free to all. Anybody could just show up and have a free meal. We have the Narragansett Lions Club annual New Year's Day plunge, which is always a favorite. The Narragansett Police and Fire Department, and also many different police and fire departments throughout the state come to the North Beach Clubhouse for their meetings and annual trainings. The annual summer concert series that we have on the deck of the North Beach Clubhouse are Monday evenings beginning in July. And we have eight to 10 concerts each year, depending on the weather. The annual Philharmonic Live concert, Friday, July 14th, attracts 10,000 people to the area. And if you haven't been there before, it's a great night in the town of Narragansett. So again, those are just some of the things that happen year round on the deck of this particular building. Not to mention, like I said earlier, all of the weddings, baby showers. Again, this deck, it's not this little building, because the building itself is small. It's the deck that really is the draw for people to be there and host their different events.
Thank you. Anything else to add from yourself or those at your table? All right.
No, sir.
Any questions from the council? So first we need a motion on, do I need to open a public hearing, even though there's no one here? Yes. Yeah. I'm gonna open on the special exception, open it up for the public hearing. And I think no one had indicated that they were going to speak on that. So we'll close the public hearing on that. And first matter for our council vote is on the special exception. So I would need a motion as it relates to the special exception request. Mr. Willis.
Can I just clarify the
Absolutely.
special exception? There's actually two special exceptions that need to be voted on. Whether or not, Mr. Chair, you want to incorporate that in one motion, but the first special exception is to allow section 1.2.2B1C3 AA as its own vote, and then B as its own, or incorporate them together. I just want to allow the council to make that decision.
We can do them separately if that's cleaner. So as it relates to the AA, then the section with the AA, let's do that one first. Is there a motion on that?
Mr. Chairman, based on the report of staff and Amy's presentation tonight and the testimony from the applicant that we've heard, and move that we vote to approve the first special exception on this application.
Is there a second? Motion made by Mr. Izzy, seconded by Mr. Gomez. Any discussion? Hearing none, I'll pull the council. Ms. Hall?
Aye.
Mr. Gagnon?
Aye.
Ms. Reynolds?
Aye.
Mr. Izzy?
Aye.
Mr. Gomez?
Aye.
I too, Raymond Coy, vote aye. As it relates to the special exception pertinent to the AA section. Next would be same section, sub B, and entertain a motion on that one. Mr. Gomez.
Based on the findings of fact and the application of the necessary criteria, it shows a compelling public purpose. They're trying for a minimum setback. They didn't find any reasonable alternative. It's a water dependent activity, and was noted, it generates money for the town of Narragansett, right? And does provide access for broad section of the public Therefore, I think it meets qualifications for a special exception, and I move that it be granted.
Thank you, Mr. Gomez. Is there a second?
Second.
Second by Mr. Izzy. Any discussion? Hearing none, I'll now poll the council. Ms. Hall,
Aye.
Mr. Gagnon,
Aye.
Ms. Reynolds,
Aye.
Mr. Izzy,
Aye.
Mr. Gomez.
Aye.
I do Raymond Coy vote aye. So the two special exceptions have been approved. Next would be a motion on the application and the variances sought. Is there a motion?
Now, move
Mr.
approval of the
Right, Mr. Gagnon.
application and the variances.
Motion made by Mr. Gagnon.
And Mr. Gagnon, does that include, is that based on a staff report as well as
Based on staff report.
testimony of the?
So testimony tonight.
Is there a second?
Second.
Who said it?
Ms. Hall.
Seconded by Ms. Hall. Any discussion? If not, I'll now poll the council. Ms. Hall,
Aye.
Mr.
Aye.
Gagnon, Ms. Reynolds,
Aye.
Mr. Izzy.
Aye.
Mr. Gomez.
Aye.
I too, Raymond Coy, vote aye. So the application has been granted. Thank you much.
All right, thank you.
Thank you, Amy.
Thank you, Chair.
Our next matter this evening is continuation of the matter. Perry Rasso for consideration and action on the proposed modifications as reviewed by CMC staff to the 3-acre oyster and bay scallop farm using floating and suspended gear in Powder Pond, Narragansett, Rhode Island. Matter was previously heard before this council, and upon a vote that passed, I don't recall the vote, but it did pass to send the matter to staff to place a modification within the area and report back to us for further discussion. And I believe, Mr. Willis, you had an opportunity to do that. Am I correct?
Yes, you are, Mr. Chair. So first off, on January 24th is when this council directed staff to look at a particular reduction of the originally presented application for Mr. Rasso. And before I get into my director's report, I want to mention that generally, when this matter would be kicked back to staff, it'd be assigned to the appropriate staff, in this case, our aquaculture coordinator, Ben Getch. And Ben did not participate in this staff review of the council direction because Ben had a previous relationship with Matunic Oyster Bar. About 10 years ago, he was employed by Mr. Rasso. There is no business relationship now. There hasn't been for that period of time, but in an abundance of caution, I advised Ben to not participate in this matter, and therefore it fell to my shoulders to handle it, being the only available staff to do that. So as you see in my director's report, I mentioned how the motion came about. And the motion was first brought up by a council member to reduce the size of the originally presented footprint of the project with a couple of other definitive recommendations that ultimately failed after a considerable amount of conversation of the council. Immediately thereafter, a motion was made that passed that directed staff to look at that previous motion with those conditions and report back to the council on whether or not that those conditions in the motion could fit within the parameters of the request. That's what my staff report does. So I want to explain that in that motion, there were basically 6 key factors for staff to consider and bring back in this report. And those key factors were: 1, that there's a modification of the application. that the basis for the reduction is based on the originally presented 3-acre footprint of the site in Cedar Cove. That the reduction of the original footprint be 39%, that the council approve an 80,500 square foot site within the originally presented footprint, that the revised footprint should be 50 feet landward, and that all floating devices would be eliminated. So we took that basic information from that motion, and in looking at it, I noticed the math didn't work with the 39% reduction of the original footprint or a 80,500 square foot approval. So based on the fact that the motion contained a call out of the size of the reduced footprint to be 80,500 square feet, not 39%, I went with the 80,500 square feet as the new reduced footprint, if you will, to see if it would fit inside the originally presented 3 acres. That was the basis for where I started. What I did, and you'll see in figure 1, was identify in blue the original footprint, the 3 acres as originally presented by the applicant. At the subcommittee, which held several, I believe 6 separate subcommittee hearings to hear this matter, the subcommittee was presented and discussed what looks on figure 1 as a configuration that's outlined in red. And it did so to address some of the issues that it found in its deliberation to be of significance to them, primarily recreational impacts and safety within the cove of those activities. So figure 1 is that representation of what we were looking at from the staff. So from that, we took the 6 key factors that the motion required, and primarily being 80,500 square feet and 50 feet to the east. You'll notice in figure 2 that a simple rectangle or fits within that original footprint as represented in figure 2, outlined in yellow. It's moved all the way to the east so that the eastern borders line up on the original footprint. And I represented it in the top northeast corner, if you will, just for representation to say that anywhere along that eastern border, this 80,500 square foot footprint could fit within the original 3 acres. So it's an infinite number of positions if you go from north to south. However, what I also looked at was the record, and the record that the subcommittee had focused primarily on what I already mentioned were recreational aspects in Cedar Cove, as well as the safety of which these activities could take place within the cove. And given that those were significant issues of the subcommittee, I reconfigured the 80,500 square feet in figure 3, represented in brown, to show that similar to what the subcommittee looked at as a revised footprint of 3 acres at 80,500 square feet, if it's configured this way in figure 3, it would address some of the recreational and safety issues that the subcommittee debated on. And that's why I took, and you'll notice in the northeast corner, I found a clip, if you will, of the corner of the reconfigured site so that it was not close to the shoreline, because if you'll remember in the record, the subcommittee discussed the fact that the original footprint at one point was 10 feet from the shoreline in Cedar Cove, and that from a safety perspective, that would not provide enough room. So by modifying that northeast corner of the revised 80,500 square foot footprint by approximately 50 feet, making a 50-foot buffer, the revised 80,500 now has a border or a buffer with the shoreline of approximately 50 feet all around. Similarly, taking into account the recreational issues that the subcommittee discussed in detail on what uses could occur inside Cedar Cove, I did the same thing in the southwest corner and reconfigured that corner, if you will, of the revised footprint to account for similar issues that the subcommittee dealt with in a much larger reconfigured footprint. So given that, I felt that the 6 criteria were met in accordance with the motion that the council approved and directed staff to look at. And I found that in looking at the recreational impacts and the safety impacts that were of concern to the subcommittee, that if an 80,500 square foot configuration could fit within the original 3-acre footprint, it would look something like what's represented in figure 3. So I felt as staff that the motion that the council approved on January 24th, we could find a configuration that would fit inside that 3 acres, and that's how I represented figure 3. The last of the 6 conditions of the subcommittee of the council's motion on that date was that there should be no floating gear in the proposal. And so that means that of what was requested of the applicant, the only remaining type of gear would be suspended lantern nets. So therefore, there's really no analysis to perform on that because the motion said no floating gear, which left only one type of gear, and that would be suspended lanterns. So that would be the only allowable gear for growing aquaculture in that area. That's my staff report, Mr. Chair, on whether or not the motion of the council on January 24th, given the conditions of the motion, could result in a configuration that would fit within the originally presented 3-acre footprint.
Based upon your understanding as to the original application, the original area that was being sought for approval, and the motion that was made the last time they were here, it's your opinion, or is it your opinion that what is depicted in figure 3 adequately satisfies the motion?
It satisfies the motion, Mr. Chair. It's not a substitute for the subcommittee's deliberations or recommendation, but it does satisfy the motion, yes.
Any questions of Mr. Willis from the council at this point, Mr. Gomez?
Yeah, my original concerns with the safety issues. I think you've done a good job. It looks like a good layout. The only thing I thought that part of the application was to do we're getting away from oysters in the deeper water where we're looking at bottom planting of cohogs or something, little nets or not. I don't remember, that's all. The depths ought to be adequate for the oyster farming, because I suspect that we move back into some shallower water.
Well, so the project looked for floating gear as well as the suspended gear and basically in the water column.
Mhm.
And the motion required that we remove any mention of floating gear. So it only left one type of gear.
Yeah, yeah.
Anyway. So there was no need to look at bottom gear at all because it only be just one type of gear.
And we've already done all of the staff and all of those other things that we normally look at.
In the normal recourse of the original application, correct?
It looks good to me. I think you've done a great job.
Ms. Wall?
I have a couple of questions relative to this issue of the elimination of floating devices. So the application, as was reviewed and out to public notice, originally called for 12 rows of 30 oyster cages. And those are the floating
Yes.
cages that are being eliminated. Those were the ones that were in 3 acres, the easternmost here. And then the application, as that went out to notice, then also added 12 rows of scallop gear, which was 50 4-tier lantern nets, right?
Yes,
And those are not considered floated because they're suspended
correct,
from submerged lines with the floats as described by the applicant
correct.
in their application. And that was to take place on the westernmost part in 1.5 acres, right? Is that still?
Originally presented.
Yeah, as presented. So if the 12 rows of 30 oyster cages, which were going to take place in the 3 acres, is out, and that was for oysters, are we then, this application as potentially modified isn't for 1.5 acres, which is the original application for the 12 rows of 54-tier lantern nets, right? Is there the idea that there'll be more lantern nets somewhere? Like, is it all gonna be lantern nets now? I guess I don't understand what's left. If you get rid of the 12 rows of 30 oyster cages and all you have left is 12 rows of 54-tier lantern nets, and they're only gonna take an acre and a half, what do we need the other 3 acres for? Like, what's gonna happen there?
Well, the motion was to reduce 3 acres down to 80,500 square feet. So that's less than 2, it's acre and a half
So
approximately.
no oysters then? Just no oysters?
The way that the application was originally presented was for 2 species,
Right.
and getting rid of the floating gear allows for only 1 now, which is the scallops and the hanging gear, the suspended gear.
So the way it looks now, then, that just so I understand, the description of the species to be cultivated in the permitted area has changed to not oysters, only scallops?
It's my understanding of what the suspended gear allows to be grown. That's right.
And so the method and manner of agriculture activity, as far as the elimination of the floating, that has changed to where it's just lantern nets and just 50, so that hasn't changed, right?
My understanding, correct.
Do we know that? I mean, it's not gonna change, right? Because I don't know. I mean, all these other things are changing. I'm not clear.
Understood. The motion was whether or not a configuration can fit within, and the motion didn't go into changing in species or different configurations of the species that would be grown.
Right, or it didn't go into a description of the method or manner of agriculture activity.
It did not.
And it didn't go into the description of the species to be managed or cultivated within the permitted area, or the description of the agriculture activities.
It did not.
Thank you.
Any other questions for Mr. Willis? Trudy Hartman, I'm just gonna ask you to just bring us up to speed as to what may need to be done or made part of a motion if the council is prepared to make a motion at this point.
Absolutely, Mr. Chair. So based on the public notice that went out for this meeting, we are confined to determining the modifications here. So if there's a motion to, let's say, approve the full application, for instance, that can't go forward tonight because under the Open Meetings Act, we don't have the proper agenda notification. If there's a motion to deny the application outright, we can't do that either because, again, that would be an Open Meetings Act violation. What we can do is we can either approve or deny the proposed modifications. If we decide to approve, then the applicant would have their project. If the council decides to deny, then the applicant would have to come before the council again for another meeting to determine whether the full project will move forward. So right now, the council just has to focus on whether these modifications are going to be approved.
If a motion would be made speculatively to approve it with the modifications, how is the subcommittee report incorporated or relied upon or referenced?
So under the statute, specifically 462320.4, the council has the ability to adopt, modify, or reject the findings and facts, findings of fact and or conclusions to the subcommittee recommendations. So if the council decides to move forward with these modifications, that would mean that the specifics regarding recreational activities such as boating, fishing within Cedar Cove would be the opposite of what the subcommittee found. And when the council makes a modification or rejects the findings of the subcommittee, it has to state the rationale therefore. So an appropriate motion might include adopting the findings and facts and conclusions of law made in the subcommittee recommendation, except for those findings of fact and conclusions of law that are related to the conflicts with water dependent uses and activities, the size of the proposed project, and whether the project conflicts with the CRMC's program. Now, once those modifications have been there's a motion on those modifications, the next question is what findings is the council going to adopt, because they need to be replaced. And my recommendation would be to look towards Dave Butel's initial staff report, as those have findings related to the fact that the recreational activities, again, such as boating and fishing, won't be harmed. There's other evidence such as meeting minutes of South Kingstown's Waterfront Advisory Commission, where the South Kingstown Harbor Master opines on the effect on boating and recreational activities. So you want to have those sorts of pieces of evidence to modify the existing subcommittee recommendation.
Okay. Any questions of Attorney Hartman?
Got one question.
Mr. Gagnon?
So is there any prohibition from us sending this revised layout to public notice so that we could get input from applicants and interveners or the public in general?
Well, there would be no prohibition, but this has been before the subcommittee, and as the executive director said, I believe it was 7 hearings, give or take.
On this layout?
Not on this particular layout.
But it's contained, in my opinion, it's contained within that which was originally depicted. So they've already commented on a larger one.
Yes, so this is, and I've been looking a lot at this. We have kind of 2 things that we're trying to balance here. We have the statute, the CRMC statutory authority, which allows us to modify not only applications, but subcommittee recommendations. And then we have a Superior Court case, and this is Easton's Point Association v. Coastal Resources Management Council, and that's 1988, Rhode Island Super, Lexus 58. Now, this case, it provides a mixed opinion because it ties in whether substantial modifications by the CRMC must be put out to public notice again. The court really ties it into whether the modification made by the CRMC also modified a local zoning decision. So I'm not convinced that this case is necessarily informative of whether the council can make modifications and whether that modification would require a second hearing and thus public notice. So the question is, do we rely on the statute or do we look at this case? Perhaps the belt and suspenders approach is looking at this case and saying, well, maybe because there's a substantial change, if there's a substantial change, that we should put it back out to public notice. But then the question becomes, is there in fact a substantial change to this application?
I have a few questions.
Ms. Hall has, let her ask her questions.
I have a few questions relative. I'm going to go backwards and start with Easton's Point and your analysis of that, and ask for just further clarification. When we send public notice of the application, right? The purpose of that is to afford the public, interested parties, abutters, other people in the industry, as well as other organizations to weigh in. And I think the issue that is sort of that we need to address is, were the changes substantive? Because I think what you've said, and what the case argues, and what CRMC argued at the time was, if our changes were more than minor, then our actions in rule, deciding a case that has changes that didn't go before the public renders public participation fairly useless, and that they haven't had the opportunity to participate because they haven't seen it. So I guess my question to you is that and I would like to also look at, before you answer it, if you could also look at the sort of the statutory authority for CRMC to even permit aquaculture. We've heard from Executive Director Willis that the description of the species to be managed or cultivated, that's changed. A description of the method or manner of the aquaculture activity has been changed. And a description of the aquaculture activities has been changed. And those are the exact parameters that the law under 2010-4 set forth, that the applicant has to have, and the application has to show, and that's what would be going out to public notice. But those things have been modified here. So I would just ask you to address both what's required in that statute and your analysis of Easton's point relative to our obligation to the public, for the public notice of the application, not for the Open Meetings Act, which I hear you on that. But I'm just wondering if you could provide some advice on that.
Absolutely. So I'll start with your second point on the aquaculture requirements. So under Rhode Island General Laws 2010 TAC 4, this is talking about the applicant's desire to permit aquaculture. And so these are the requirements that the applicant has to put forward. Now, the CRMC's authority is set out under Rhode Island General Law 4623-62B, as well as 624 Roman numeral I. In both of those instances, the first one, B, it allows the council to modify proposals. On the second one that I'd mentioned, that's 4 Roman numeral I, it allows the council the ability to issue, modify, or deny permits for any work in, above, or beneath the areas under its jurisdiction, including conduct of any form of aquaculture. So I don't think we're butting up against 20 TAC 10 TAC 4, because that's what the applicant's responsibility is, whereas CRMC has pretty strong authority to modify the aquaculture application. So that's to the second point that you're asking about. The first point for a further in-depth analysis of Easton's point, again,
Relative to our application for public notice and for the opportunity to participate.
right.
But a member of the public, industry, et cetera.
So first with Easton's point, you'd mentioned that you had said that minor changes to the plan
No,
need to be put out back out to public notice.
not minor. I think the language is, and what Attorney DeSisto told us at the last hearing was not minor. So to his point, for public notice, it was a new jurisdictional area. That's not an issue. Impact to different riparian landowners. I don't know if that's clear. Not minor, more substantive. So that was what his advice had been at the last hearing. And that's, I think, based on Easton Point language that you've discussed.
Yes, so I agree with Attorney DeSisto. That's the language that I would look for. And I think that comes later on in the case.
Right, so is that a question for us to decide if the changes in this modification that change the gear and change the species and change where the gears, where this particular gear is going to be located, because it is that location of that gear now has moved within the set area,
Certainly.
whether or not that's substantive or minor or not minor. I mean, we went from gear that was floating at just below the surface area to gear that's now suspended just above the sediment. That gear was included, but was it in this location? I just don't, that's a question I think that concerns me.
So unfortunately, I'm just the legal counsel, so I can't make that policy determination of whether really it constitutes substantial as determination that the council has to make. But what I can say is I'm really not satisfied with Easton's Point as a guidepost, because Easton's Point really it intertwines CRMC's authority to modify with whether a public hearing needs to be had at the local level on zoning board, perhaps. So it doesn't necessarily convince me that the modification that the council makes under 4623 needs to go back to public hearings. But if we're going to look at that language and read into that language, just to have the belt and suspenders approach and to be extra careful, this particular language I think we look at is whether there's been a substantial change. So if there's been a substantial change to the application, then going to public hearing might be appropriate. But that again is a determination the council has to make. Is like you said, the size, it's shrinking. That seems like that would be a minimal change. But as to gear, I can't speak to that. That's a council decision. But again, I think that's the belt and suspenders approach.
It's what I use.
Mr. Gomez.
My take on it is that we have the authority to modify the original application as it passed through the subcommittee. And I think everything we've done is inside an area that's already been discussed. And all the changes are a reduction along the lines that the subcommittee had discussed. And, the floating gear, you went through, I think, 6 points or something that it's all, the safety issue was taken care of, the floating gear was taken care of, and you contained it within the area that was originally discussed. I just don't see the problem with going ahead with this modification that reduces everything. We're not adding anything or making things worse. We're staying compliant with local zoning codes. The bottom structure, plants, everything else is the same, with the exception of a number of modifications. I just don't see a problem with that unless the applicant is, really doesn't want that much reduction. But I think it's a starting point. I think it's something we could approve the modifications and see where that goes, I guess. But I just don't see the conflict. And I would expect if we do this, that sometime in the future, if the applicant wanted to increase the field or change gear, he'd have to come to us again for that modification, and that would have to go to the open meetings law and be heard. So from my viewpoint, we're just reducing everything to be compliant with the recommendations that were previously made.
I'm of the same opinion, because you've got a smaller area, you have less gear, you've cut corners where there's been issues of safety. So I look at it that if it was originally this big and all the people were against it, now it's smaller with less gear, at best, all those people are still going to be against it. There's no need to put it out to them. It's just a smaller area and less gear.
Absolutely.
Yes, Mr. Izzy.
Just to follow up on what Don was saying. We have to, I think, first define and understand what standard we're looking at, and when it says that we can modify an application except where there's a substantial change to the application. I mean, in statutory interpretations and interpretations of semi-ambiguous terms, you have to apply common sense to them. And I think if you look at this application and what we're doing with this application, the modifications that we're making to the application, it supports your argument. Substantial change, in my opinion, means an expansion of an application or an addition to an application. We're not adding anything to the application. We're eliminating things from the application. We're not adding any, we're not increasing the size of the aquaculture beds. We're reducing them. I can't imagine under any definition of substantial change that would include what we're doing here. I think it's just the opposite. Everything that has been, everything that the applicant put forward 6 years ago has been gone over and debated and argued about for the past 6 years. It's all there. All we're doing is taking some of the gear out, taking oysters out, but leaving one of the species that they applied for in the area that they applied for originally, and reducing the amount of the area, but keeping the remaining area inside the boundaries of the original application. I just don't see this as a substantial change to the application. I think it's a de minimis change to the application because there's no increase in anything that the applicant is looking for.
Thank you. That's all.
I want to follow up with that and with respect to my colleagues' positions, which of course I respect, I have some additional follow-up questions that relate to the fact that I think the language doesn't say a substantial change is an increase. And it is an environment that's not, a flat environment. We're not citing a building on land, it has the water and the submerged area and the water column, and there are changes happening there. So substantial change isn't just aerial change. We're not permitting where that speaker is going to land on that table. And I think my question to you, to the executive director, is when we look at what's in the application relative to the location of different forms of gear with this configuration that has been essentially designed by the staff, CRMC, based on this motion from January. The original application had the lantern, that's the scallop gear, which is suspended below the water column to 1.5 feet above the seafloor. So in that water column area, was closest to the center of the cove in the westernmost part of the farm. So we have now moved the location of that gear eastward. Is that correct? Based on your understanding?
Based on my understanding, that would be correct.
So that gear has moved closer to shore, eastward. And the gear that was eastward is not there. So it is a completely new form of gear in a new location. It isn't new to the project, but it's new to that area. And it's new to that part of the water column. And it's new to that part of the area of water that's closest to the abutters. And it's changing the use of that resource. It's putting something new and different in that spot where it wasn't. In the area where it was, it isn't there anymore because you've cut that area out. The staff has cut that area out. It responsive to this motion. Is that correct? Based on your understanding of what you guys put forward here in figure 3?
What I put forward.
Yeah.
I want to make that clear that.
It is really clear.
Ben did not participate.
Right. And also the applicant didn't participate.
Correct. No, I took the original footprint. I took the 80,500, moved it as far east as I could.
Yeah, given
Within
the
that.
confines of the motion
Of
that
the
you were
motion,
stuck with.
correct.
And I just think there's the idea that the ocean or the coast is sort of this flat, one-dimensional thing. It's just, that's just not how this works. There are impacts when you change gear in the water column and you put it in a new location. It's not about size, whether it's large or not. It's the fact that the ecosystem, there's an impact, there's a difference, and we don't know what it is because we don't have those facts. We don't know. We're just hearing now it's a different species than both species. So if we've learned nothing from our past, as far as transparency as a public agency, reviewing applications, 6 years ago, the public saw an application. It doesn't look like that now. And what's going to come out the other end isn't going to be what they thought was going in. And it wasn't what we spent 7 weeks of hearings on. And it wasn't what they spent money on and hearing and witnesses and testimony and experts testifying to, because it's different. And although we can change it, how much of a change do we really want to be responsible for that hasn't been reviewed? That's a question. It's not about just size. So I'm concerned about that.
You all said, yeah. Just, I go back to the fact that it's a reduction in what was requested. It's a good starting point after we were in COVID doing, the laptop discussions on this that went on for hours and hours and hours. And this is just a culmination of trying to get this thing off top dead center. You talk about scallops. Our saltwater ponds were loaded with scallops. I had a 16-foot aluminum boat and I happened to have a scallop drag. I'd come over here and drag for scallops and they disappeared. Previous to that, oysters had disappeared. They're coming back. The oysters especially, it's been a great benefit for the fishermen. I mean, they're being pushed around. People are actually able to come into the salt ponds and make a living on aquaculture. I love to see the expansion. I see that the scallops that were once native here are not going to hurt anything in the pond that they actually grew up in previous decades. So I reject the idea that scallops are going to change anything. The ponds got to a point they were either overfished or the things happened with the water quality that these things died off. Now we're trying to, they can only benefit to try to bring them back. That's my opinion. And I still support to get this off top dead center and support the modifications.
Any other questions of our legal counsel?
We have another question relative to off the public notice issue, relative to the issue of the situation that we put staff into, which is they had to go out and draw this and then decide it, recommend it. And I believe it's fairly established that the agency who's in charge of reviewing an application, the burden of proof to prove that the application meets the law is on the applicant, not on the staff. The applicant comes forward, and applicant has the burden of proof to determine whether the application can be approved. And putting the staff in this position of drawing something to recommend, as the executive director has said, I don't know about this. We did the best we could given the motion. We don't really know about changes in gear. We don't really know whether, how many, if any, additional changes will be made. I don't know that's, I believe it's fairly well established that if it's the applicant's burden to do that, it's not the staff's burden to do that. And then having the staff make a recommendation of something that they drew is a conflict. And I think it's outside of what Rhode Island law allows.
Well, I think the applicant, their burden, they put forth voluminous evidence, experts, and testimony as it relates to the entire project. So, I mean, they could come here and say, we've met our burden of proof, we want everything. And all the evidence substantiates that. What we're doing is chiseling away a little bit of it. So we're not saying Jeff has to come here and meet the burden of proof. What Jeff is saying is that what I put forth to you, council members, is a reduction, as you asked me to do, in the bigger picture that the applicant has put forth all the evidence for their burden of proof. So I don't see it that way at all.
No, I guess what I'm saying is that the issue is they could come back and ask for it all. The subcommittee has already denied the application. Our standard was.
Well, they made a recommendation.
They made a
I made a
recommendation.
recommendation to do that.
Yeah.
And our standard was to review that recommendation and either approve it or.
Approve, modify, or deny.
Well, we
Right,
can
modify
deny
or
that
deny.
and we can approve the entire project
Right,
with
but,
everything that the applicant wants.
but the dual role of advocating for a position, figure 3. And also recommending whether we approve it or not. You know, I don't know that that's a proper role for the.
I don't see, I'm gonna jump in for a second. I don't see Jeff advocating for it. I think he's saying, you asked me to do something, this is what you asked me to do. Do with it what you want.
Well, then let's think about our role as a council. We asked him to make this change.
And he did it.
I know. And now we're ruling on the thing we asked them to do. Are we an impartial arbiter? Are we an impartial?
No, our role is, I mean, it's as if when we sit here on applications for dock and we'll look to staff and say, what do you think about a modification of 5 feet? And they'll talk to the applicant. Can you do 5 feet less? Yes, yes. And then we approve it that way. So it's,
Right.
they're not advocating anything. They're facilitating something that we asked them to do. So I think it's properly before us.
I would agree with the chair in that point. I think that this is something that, this is essentially an extension of the modification discussion.
Okay.
And this is an important visualization of that.
So the issue is the scope of the modification relative to public notice.
Yes.
Okay, thank you.
Anything else? The council prepared to make a motion? Mr. Gomez? I thought I heard you say yes. Did you?
The council is ready.
Oh,
This is just, I made a good living by thinking out of the box. This is so far inside the box that, we shouldn't even be discussing it, but I would move that the modification be accepted as proposed, and that we're adapting the findings of the subcommittee and the subsequent incorporation of those in the proposed modification. And you indicated I needed to put some exceptions in there for conflict with other uses, and that you had 2 exceptions that I forgot.
Yes, Mr. Gomez. So the subcommittee recommendation, the basis for the denial was the conflict with water dependent activities, water dependent uses and activities. So we need to, if the council so pleases to approve this modification, they need to contradict those findings and provide a basis for that. So we would need to make an exception for the findings regarding water dependent uses and activities. So size of the proposed project and conflict with the CRMP.
So moved.
And
Can I do that?
yes. But also in that regard, you would need to adopt findings that replace the modification that you just suggested.
So we are the motion places the subcommittee recommendations with the present proposed modifications. Is that correct?
And there has to be some basis, so
Based on Dr. Butel's original report with that and.
The harbor masters.
This is in the harbor. This is a group effort in the harbor masters in the harbor master and all the previous material, the hours and hours and hours that we've gone through on the discussion. I think covers everything we need to do. The recreational activity modification for that was an exception with with conflict to the others, recreational activity being it. And that we believe that this is okay, right? And then the other is based on previous meetings and all the material that we have, that I think the changes reflect all the material that we went through up to the subcommittee, and now this is just a culmination to modify some of those findings to reinforce the safety aspects and the recreational aspects of the farm. Anything else I need to say?
Mr. Gomez, I think that covers it.
There a second?
Second.
Motion made by Mr. Gomez, seconded by Ms. Reynolds. Will now poll the council. Mr. Izzy.
Aye.
Excuse me, is there discussion on the motion?
Oh, yeah, I can do the discussion. I'm sorry. Motion made and seconded. Any discussion? Ms. Hall?
Based on legal counsel's interpretations and advice that more than minor modifications could result in the need for public notice. And you've said that the question of more than minor is up to us to decide based on what we know.
Substantial changes.
Right, more than minor, substantial equals more than minor.
I think
Is that what you said?
in the Easton's Point case, the more than minor was an argument that was made by Easton's Point.
Right, and that's what Attorney DeSisto advised us at the last meeting, and you said you agreed with that. Is that what you said, or did I misunderstand you?
I was agreeing that it's a substantial is the standard that we're looking at.
Substantial, not more than minor.
Yes.
Okay. And that we've heard from the executive director that the gear itself has been changed relative to its location within this new area, that there is new gear in a new location that wasn't subject to the public notice that gone out, wasn't subject to the hearing. And that interested persons who might have acted on that modification or on that design were not able to participate in that hearing because that wasn't what was before us. And they're not able to be put on notice that that's a change. I think that is a substantial change. So I think I just wanted to clarify from legal counsel that substantial is a standard and it is applied to change, and that leaving it up to us, I guess my opinion based on what I've heard in facts is that this is a substantial modification. Well, that I think should go back out to public notice.
If I may, I think that the Easton's Point is not necessarily the picture of clarity on this. It seems to be the only case that's out there regarding modifications. And it really ties in to the zoning. But like I said before, the belt and suspenders approach is to use it as a guidepost, even though it may not be the best. That's the belt and suspenders.
So we are using it as a guidepost.
Even though it may not be the best guidepost.
Yeah.
Any further discussion?
We move the motion.
Yes, Mr. Izzy. Aye. Mr. Gomez.
Aye.
Ms. Hall.
No.
Mr. Gagnon.
No,
Ms. Reynolds.
Yes.
I too vote aye. The vote is 4 in favor, 2 opposed, so the motion carries.
Yes.
Having nothing else to come before us, I'd entertain a motion to adjourn.
Mr. Chairman, before you adjourn, just Executive Director Ross and Mr. Herman, just for the record for the interveners, just note our objection to the proceedings.
Your objection is so noted.
Just identify yourself, Chris, for the rest of
Sure, I'm sorry, Mr. Chairman, Christian Capizzo, CAPIO, representing interveners, Hunt, Rooney, Quigley, and Latham.
Also, Mr. Chairman, Dean Wagner, I have he's not my objection.
Thank you.
Objection so noted.
And entertain a motion to adjourn. Entertain a motion to adjourn.
Move to adjourn.
There are members of the public here who came, would like to comment.
Second and all in favor, say aye.
Aye.
Opposed? Motion carries.
It's not a public hearing.
I didn't-
Motion.